The hand came first. No words, no lights, no question. Just a hand, thick-wristed, certain of itself, reaching across the dark, and closing around an arm that had done nothing except exist in a driveway on a Tuesday night in October. The man it grabbed was named Samuel Archer. He was 58 years old. He was standing in his own driveway, in front of his own house, holding his own groceries. He had lived on Callaway Lane for 19 years. He knew the name of every dog on the block. He had shoveled his neighbor's walk the previous 3 winters. Without being asked, he had come home from the grocery store with salmon and a bottle of sparkling water and a card for his wife's birthday, which was Thursday, and he had been in the process of doing the particular calculation of whether to make 2 trips or balance everything in one, when the hand found his arm in the dark. The officer's name was Derek Voss. He was 29 years old. He had been on the force for 4 years. He said later, in the report he filed within the hour, that he had received a call about a suspicious individual in the Callaway Lane area and had responded and observed a male subject in the driveway of a residential property and had attempted to make contact. He used the word attempted, as though contact were something that required effort rather than consent, as though the arm he had grabbed belonged to someone who had not yet earned the right to stand where he was standing. Samuel Archer said, in the report he filed the following morning, that the officer had not identified himself before making physical contact, had not stated the nature of the stop, had not given him an opportunity to speak before the hand arrived, had pulled him 2 steps back from where he was standing, toward the street, away from the door he had been about to open. What neither report fully captured, what no report has the language for, was the moment that came next. The front door of the house at 14 Callaway Lane opened, and the woman standing in the doorway, backlit by the warm interior light, in reading glasses and a cardigan, holding a book she had been reading for the past hour and had come downstairs to check when she heard something. Outside was the Honorable Patricia Archer, Associate Justice of the State Court of Appeals, 18 years on the bench, recipient of the State Bar's highest judicial honor. The woman whose name was on the courthouse downtown in the form of a procedural reform that had rewritten how evidence was handled in appellate review. The woman who had been married to Samuel Archer for 31 years, Derek Voss, looked at her, and the color left his face the way color leaves a thing when the source of it is suddenly withdrawn. Not gradually, at once. Subscribe, and tell me where you're watching from in the comments. Rewind 32 years. Patricia Archer was not born into the law. She was born into a house in North Carolina where the law was something that happened to people rather than something they wielded, and the distinction between those 2 experiences was the organizing fact of her childhood, in the way that certain facts organize everything around them without being post-spoken. Her father was a postal worker. Her mother taught 2nd grade at the elementary school, 4 blocks from their house, and walked to work in all weather. Because the car was her father's, and her father needed it for the route. They were not poor in the way that announces itself. They were poor in the way that requires constant management, constant small decisions, constant awareness of the distance between what is needed and what is available. Her parents managed this distance with a competence and a dignity that Patricia would not fully appreciate until she was old enough to understand what it cost. She was the eldest of three. She had the particular temperament of the eldest, responsible, watchful, inclined to understand systems because systems are what the eldest learns to navigate first. She watched how things worked. She watched how the school worked, how the neighborhood worked, how the particular machinery of her town processed people differently, depending on factors that had nothing to do with the people themselves. She watched this without the vocabulary to name it, and filed it in the place where children file the things they know before they can say them. She read constantly, not because anyone told her to, but because books were the place where systems were visible, where you could see the machinery clearly, because it was on the page and not moving. Her mother brought books home from the school library on Fridays. Her father, who had a route that took him through the university district, would sometimes bring her a paperback that had been left in a hallway or a common room, his version of bringing home something the household did not strictly need, but that he understood his daughter required. E. E. She decided she wanted to be a lawyer at 16, not in a gradual way, in the specific, sudden way that a decision sometimes arrives, fully formed, from an accumulation that has been building without your awareness. She was sitting in her high school's library, reading about a civil rights case, the mechanics of it, the arguments, the language of the brief. And she had the experience of recognizing something she had always understood but had never seen written down. The law was a system. And systems, unlike the raw exercise of power, could be argued with, challenged, changed. The law was the place where the machinery could be examined in the open, where the examination itself had rules, where the rules theoretically applied to everyone. Theoretically. She understood the theoretically. She had grown up inside the distance between the theory and the practice, and she had filed it in the same place. She filed everything else she knew before Kachis. She was going to become a lawyer, and she was going to work in that distance. That was the decision. It arrived at 16, and it never revised itself. Met she Samuel Archer at a study session in her second year of law school. He was not a law student. He was finishing a graduate degree in urban planning, and he was in the law library, because the urban planning library had been closed for renovation, and a classmate had told him the law library had the city's zoning archives he needed for his thesis. He was at the table next to hers. He was eating an apple with the focused, unself-conscious pleasure of someone who has forgotten he is in public. Patricia looked up from her property law textbook and said, without particular warmth, the eating policy in this library. He looked at the apple. He looked at her. He said, I'm sorry. Is there a policy? There is. What is it? No eating. He looked at the apple again. He looked back at her. He said, and yet you're the first person who said anything. I've been here 40 minutes, she said. 40 minutes of violation is still violation. He put the apple in his bag. He looked at her for a moment with the expression of a man who has just encountered something he finds unexpectedly interesting. He said, are you always this precise? She said, I'm in law school. He said, that explains it and also doesn't explain it. She almost smiled. She returned to her textbook. 12 minutes later, she said, without looking up. What are you looking for in the zoning archives? He told her. She told him where they were. He found them. 2 hours later, when they were both leaving, he held the door and said, "Thank you for the navigation and the apple enforcement." She said, "Don't eat in the library." He said, "Can I take you to dinner instead?" She almost smiled again. This time she let it become an actual smile. They went to dinner the following Friday. They talked for 4 hours. He was precise in his own way, methodical, attentive, the kind of listener who does not merely wait for his turn, but actually absorbs what is being said and responds to it directly. He had grown up in Alabama, the son of a contractor and a librarian, and he had the specific combination of those influences: a practical understanding of how things are built and a deep, habitual relationship with what has already been built and written down. He was funny in a way that arrived quietly, without announcement. He had opinions that he held with confidence, but not rigidity. He changed his mind when the evidence was sufficient. She thought, sitting across from him over the remains of dinner, "Here is a person whose internal architecture I would like to understand." She spent the next 31 years understanding it. He became an urban planner. He worked for the city for 16 years and then consulted for 11 more, and his specific expertise, the relationship between zoning decisions and neighborhood outcomes, the long downstream consequences of where a city decides to put what, was the kind of expertise that is not famous, but is foundational. Cities, he had advised, were different than they would have been without him in ways that were real and measurable, and entirely unattributed in any public record. He was the person who shoveled the neighbor's walk, who knew the name of every dog on the block, who had lived on Callaway Lane for 19 years, with the ease of a man who has arrived somewhere he intended to be and has no plans to leave. He was standing in his driveway on a Tuesday night in October, holding salmon and sparkling water and a birthday card when Derek Voss's hand found his arm in the dark. Patricia heard it before she understood it. A sound from outside, not loud, not violent, but with a quality that was wrong, in the way that certain sounds are wrong before you can identify the wrongness. She set her book on the side table and went to the window first. She saw the police cruiser, lights off, idling at the edge of the driveway. She saw Samuel. She saw the officer. She saw the hand. She was at the front door in the time. It takes a woman who has been a judge for 18 years to decide that the moment requires her presence. She opened the door. The light from inside the house fell outward onto the driveway and landed on Samuel and the officer and the particular geometry of what was happening between them. The hand on the arm, the groceries, the 2 steps back toward the street. And it illuminated all of it with the unhesitating clarity of something that has been brought into the light and cannot now be put back into the dark. Derek Voss looked at the woman in the doorway. He did not know her. He had been on the force 4 years and had worked this district for 2. He did not know Patricia Archer's face the way people who read the courthouse notices, or the bar association announcements, or the local legal news knew it. He saw a woman in a cardigan with reading glasses and a book backlit by warm interior light, standing in the open doorway of the house at 14 Callaway Lane. She said, in the voice she used in chambers, which was quieter than her courtroom voice and considerably more precise, "Officer, why are you holding my husband's arm?" The 4-second pause that followed was witnessed by 3 people. By Samuel, whose groceries were getting heavy, by the woman 2 doors down. A retired school teacher named Dolores Farr, who had come to her own window when she heard the cruiser, and by the young man across the street named Marcus, 19 years old, who had been sitting on his porch and who had the presence of mind, in the moment he understood what he was watching, to pick up his phone. Derek Voss said, "Ma'am, I received a call about a suspicious." Patricia said, "Officer, I asked a specific question. Why are you holding my husband's arm?" He released the arm. She said, "Thank you. Now, what is your name and badge number? And what is the nature of this stop?" He told her his name. His badge number required a second ask, delivered with the particular patience of a woman who has waited out far more resistant witnesses than a 29-year-old patrol officer. In a driveway, she said, "And the call that brought you here. What specifically was the nature of the report?" He said, "A suspicious individual in the vicinity." She said, "This is our driveway. This is our home. My husband has lived here for 19 years. What element of his presence in his own driveway constitutes a suspicious individual?" The question was not rhetorical. She waited for the answer, the way she waited for answers in court. Without impatience and without mercy, simply with the absolute certainty that the answer was going to arrive and that she was going to hear it. Derek Voss did not have an answer. She said, "I'm going to need you to explain precisely what probable cause or reasonable suspicion you had before making physical contact with my husband." The silence that followed was the sound of an officer understanding, fully and without further assistance, the dimensions of what he had done and where he was standing and who he was standing in front of. Dolores Farr, at her window, later told her sister that she had witnessed many things in 67 years and that what she saw on that driveway was the most complete and efficient delivery of accountability she had ever witnessed, and that it had taken less than 4 minutes, and that the officer's face had been, at various points, the color of the white trim on the house. Marcus, across the street, was recording all of it. He had been recording since the moment the door opened. The video was 41 seconds long. It began with the door opening, the warm interior light falling outward, and it captured Patricia Archer's first question and Derek Voss's hand, releasing Samuel's arm and the badge number exchange, and the probable cause question, and the silence that answered it. It did not capture everything that had happened before the door opened, because Marcus had not started recording before the door opened, and he said later that he regretted this and then said that what the video captured was sufficient, which was correct. The video was posted at 11:17 on a Tuesday night. By Wednesday morning, it had been viewed 200,000 times. By Wednesday afternoon, it had been viewed 1.4 million times. By Thursday, Samuel's wife's birthday, it had been viewed 4 million times, and a producer from a national news outlet was sitting in a rental car outside a studio waiting for a satellite window, and a reporter named James Okonkwo, who had covered civil rights and policing for 11 years and who had seen many videos, watched it 4 times in a row, and then called his editor and said, "I need to go to Calloway Lane." He went to Calloway Lane. Patricia Archer agreed to one interview. 1. She chose James Okonkwo because she had read his work and believed he understood the difference between a story about a moment and a story about a system. She sat across from him in the living room of the house at 14 Callaway Lane, the same house whose front door had opened onto a driveway the previous Tuesday. And she spoke for 37 minutes. She said that her husband had been in his own driveway. She said that he had been grabbed before a single word was exchanged. She said that probable cause is not a technicality. It is the foundational protection that exists between a citizen and arbitrary power, and when it is bypassed, not in a high-pressure situation, not in the fog of ambiguity, but in a residential driveway on a quiet street in October, something essential is being said about who the protection is understood to apply to. She said that she was a judge, and that her being a judge was not the reason this matters. It was not the reason it was wrong. It would have been wrong if she had been a nurse, a teacher, an electrician, a postal worker. The address of the house and the occupation of the woman at the door should not be the variables that determine whether a man is grabbed in his own driveway. James Okonkwo said, "Do you think Officer Voss knew who you were when he released the arm?" Patricia was quiet for a moment. "No," she said. "He released it because I asked him a direct question, and he did not have an answer. I want to be specific about that. He released it because the question exposed the absence of justification, not because of who I am." A pause. Who I am should not have been necessary. The interview was published online within 24 hours. It was read widely. The headline, which James Okonkwo had written himself, was 7 words. The door should not have been necessary. Those 7 words were shared 300,000 times in 48 hours. The departmental review opened within 72 hours of the video's publication. It was not opened because of the video precisely. It was opened because the video had created a public record of an event that a review was now obligatory. And the distinction matters because events that require a video to become reviewable occupy a specific and troubling category that the department's own Internal Affairs Division noted in its initial memorandum. The review examined 3 things. The first was the call itself, its origin, its content, and whether it met the threshold for the response that was generated. The investigation determined that the call had come from a number that was not registered to any resident of Callaway Lane, and that the specific content of the call, a suspicious individual in the driveway, had been transmitted to Officer Voss without the dispatcher flagging the absence of any specific suspicious behavior in the caller's description. The dispatcher's handling of the call was separately reviewed. 2 procedural protocols were subsequently revised. The second was the conduct of the stop. The review found that Officer Voss had made physical contact before identifying himself, before stating the nature of the stop, and without any documented basis for reasonable suspicion specific to the individual he encountered. The report used the phrase procedurally unsupported contact 4 times. Patricia Archer, who read the report the day it was released, later noted in a public statement that the phrase procedurally unsupported was technically accurate and that the word unswolsted was doing considerable work in that sentence. The third was pattern. This was the review that took the longest, and it was the one that Derek Voss had not anticipated when the initial inquiry opened. The pattern review examined every documented stop, interaction, and use of contact in Officer Voss's 4-year record and cross-referenced them by location, time, and the demographics of the individuals involved. The findings of the pattern review were not released publicly in their entirety, but the summary noted a statistically significant disparity in the rate of physical contact initiated prior to verbal exchange in stops involving black male subjects as compared to all other demographics. The findings were forwarded to the county prosecutor's office. Derek Voss was placed on administrative leave pending the review's completion. He was not dismissed immediately. He was not charged immediately. The machinery of institutional accountability moved at the speed. Institutional accountability moves, which is not the speed of justice and not the speed of video, and not the speed at which a door opens at 14 Callaway Lane, and changes the nature of a Tuesday night in October. 3 months later, Derek Voss resigned. His resignation was accepted. His personnel file was transferred and sealed. Chief of Police Annette Reyes held a press conference. She read from a prepared statement that had been reviewed by the city attorney's office. She said that the conduct documented in the review did not meet the standards of the department. She said that procedural reform was underway. She said the department was committed to rebuilding trust with the communities it served. She answered 6 questions. The 6th was from James Okakwo, who asked Chief Reyes, how many stops of this type occurred in the Callaway Lane district in the past year that were not recorded on video? The silence that followed was 7 seconds long. She said, that is part of what the ongoing review is examining. James Okonkwo wrote that answer down and did not ask a follow-up question because the answer had already said everything. Patricia Archer did not attend the press conference. She was in court that day, as she was most days, doing the work of an appellate judge in a state court system that had approximately 412 cases, more than its docket could comfortably hold. She sat on the bench in her robe and heard arguments and asked questions and wrote opinions that would not be famous and would not be on television and would determine in their careful and specific way the shape of the law as it actually functioned in the lives of actual people. This was, she had decided at 16, the work. She came home that evening, and Samuel was at the kitchen table with city planning documents spread across it, which was his version of the same thing. She made dinner. They ate together. She told him about a particularly sharp brief she had read. He told her about a zoning proposal that was going to create downstream problems that nobody had modeled yet. They talked about their daughter's visit the following weekend. They talked about the birthday dinner they had not had because the birthday had been the day after the driveway and the mood of the occasion had been altered in ways that required some time to pass before they could be restored. They rescheduled the birthday dinner for 3 weeks later. Same restaurant. Salmon, as it happened. A bottle of sparkling water. They held hands across the table in the way they had held hands across tables for 31 years, which was not a gesture of performance but of fact. The fact of 2 people who had decided to be in each other's company and had found no reason to revise the decision. Samuel said, over dessert, the Reyes press conference. Patricia said, I read the transcript, the Okonkwo question. Yes, a pause. How many do you think? Samuel said, without the video. Patricia was quiet for a moment. She looked at her husband across the table. She thought about the 41 seconds of recorded footage that had existed, because a 19-year-old named Marcus had been sitting on his porch and had understood what he was watching and had had the presence of mind to document it. She thought about all the driveways on all the Callaway lanes in all the jurisdictions where the door does not open, where no one is at the window, where the 19-year-old on the porch does not have his phone or does not reach for it or reaches for it 1 second too late. She said, "That's the question." He nodded. They sat with it, not in despair, not in anger, but in the specific quality of attention that people pay to the things they have decided to do something about. She filed the formal judicial complaint herself. She was not required to. She was entitled, as any citizen was entitled, to file a civil claim. She was entitled, as a judge, to refer the matter to the oversight body and let the institutional process conclude at its own speed. She did both of those things. But she also did a third thing, which was the thing that in the subsequent months would have the most durable effect. She wrote an opinion, not a case, not from the bench, not as a ruling. She wrote a formal essay submitted to the State Bar Journal titled The Driveway and the Door: Probable Cause, Presumption, and the Geography of Safety. It was 11 pages. It was precise and documented, and argued with the specific force of someone who has spent 18 years thinking about the relationship between the written law and the lived experience of it. It examined the legal standard for reasonable suspicion, and the distance between that standard as written and the standard as applied in documented stop and contact incidents across the state over a 10-year period. It used footnotes and citations and empirical data and the particular language of the law that people inside the law read and act on. It was published in the State Bar Journal. It was reprinted in 2 national legal publications. It was cited in a brief filed in a federal case 6 months later. It was entered into the record of a state legislative hearing on policing standards, at which Patricia Archer testified for 47 minutes without notes. The hearing produced a bill. The bill was argued in committee for 4 months. It was amended 7 times. In its final form, it required documented articulation of specific reasonable suspicion before physical contact in any non-emergency stop, mandatory body camera activation at the initiation of any resident stop, and an independent civilian review mechanism for pattern analysis of stop data by demographic. It was signed into law on a Thursday morning in March. The governor's office sent flowers. Patricia Archer put them on the kitchen table and looked at them for a moment and then went to court, where she had 3 oral arguments before noon. 6 months after the law was signed, a ceremony was held at the state courthouse to mark its implementation. There were remarks from the governor, from the speaker, from the head of the state NAHEP, from Chief Reyes, who had, in the intervening months, implemented the new protocols within her department ahead of the legislative deadline, and who said in her remarks that the hardest things about the was understanding that a 41-second video should not have been the mechanism by which the system examined itself. Patricia Archer was introduced last. Samuel was in the audience. In the 3rd row, he had his plank documents in his bag, because he had come from a morning meeting and was going to another, and he was the kind of man who does not stop working when there is work to do. He had his documents and a bottle of sparkling water, and the particular expression of a man watching his wife do the thing she decided to do at 16 in front of a room that is only now catching up to where she has been all along. Patricia spoke for 12 minutes. She said that the law was not complete protection, that no law was complete protection, that the distance between a written standard and a lived experience was the work, the permanent, unfinishable, absolutely necessary work of everyone in the room and outside it. She said that she had not opened her front door on a Tuesday night in October to become a story. She had opened it because she heard something that was wrong. She had said something, because she had the tools to say it, and the tools should not be the exception. She said, "My husband should be able to stand in his driveway. Every husband, every wife, every person should be able to stand where they have a right to stand without requiring the right person to open the right door at the right moment." She stepped back from the podium. Samuel was looking at his hands in his lap. His jaw was set in the way it set when he was holding something he did not want to display in a public room. Dolores Farr, who had been invited as a community witness to the ceremony, reached over from the seat beside him and put her hand briefly on his arm. He looked at her. She said, 19 years I've known you two. Should have been sooner. He said, yes. But here, she said. He said, yes, here. True wealth is what you give back when nobody's watching. Marcus, the 19-year-old, who had been on his porch with his phone, was in his first year of community college when the law was signed. He was studying criminal justice. He had not decided yet exactly what that meant in terms of a career, whether it meant law enforcement, or law, or policy, or advocacy, or some combination of those things that did not yet have a clear name. He had time to decide. He was 19, and he was paying attention, which is the most important thing you can be doing at 19. He was quoted once in a follow-up piece James Okonkwo wrote on the anniversary of the video. James asked him what had made him reach for the phone. Marcus said, "I knew what I was watching. I'd seen it before. Not there, not on that street. And I thought, somebody should see this, not just me." James said, "What do you hope people saw?" Marcus was quiet for a moment. "That the door opened," he said. "That somebody was there, that it mattered." James wrote that down. He published it at the end of a long piece, in the final paragraph, without comment. It did not need one. The part that stays with me, the image I return to, the one that will not settle, is not the driveway. It is not the hand on the arm. It is not even the door opening, though the door is everything. It is the groceries, salmon, sparkling water, a birthday card, the specific, ordinary content of a Tuesday evening. The proof. If proof were needed, and it should not be needed, and yet here we are, that Samuel Archer was not in his driveway for any reason that requires justification. He was in his driveway because he had been to the store and he was coming home. And home was the house at 14 Callaway Lane, where he had lived for 19 years, and where the light was on and his wife was reading, and Thursday was her birthday. The groceries are the part that I cannot put down, because they are the argument, not the degree, not the career, not the 31 years of marriage, not the door opening on a woman in a cardigan who turned out to be an appellate judge. The groceries are the argument, They are what he was holding. They are what everyone is holding, in every driveway, on every Tuesday. The ordinary content of an ordinary life that does not require special credentials to be lived in peace. The universal truth this story carries is about the difference between rights as written and rights as experienced. Patricia Archer knew this difference before she was a judge. She had been filing it since she was a girl, watching how her town processed people differently, depending on factors that had nothing to do with the people themselves. She had spent her professional life working in the distance between the theory and the practice. And then the practice arrived in her driveway, and she opened the door, and she did what she had been doing for 30 years. She asked the precise question and waited for the answer, and the absence of an answer was itself the answer. The question I need you to sit with tonight is not comfortable. I am not going to make it comfortable. How many times? How many ordinary Tuesday nights? How many driveways? How many hands on how many arms? Happen without the door opening, without the person at the window, without the 19-year-old on the porch who reaches for his phone in time? Leave the answer in the comments in one word. The honest word, not the one that makes you feel better about the answer. The true one. One word. If this story reached you, if it moved something in you that you want to do something with, pass it to someone who needs to understand the distance between the law as written and the law as lived. Not to make them angry, to make them specific. Anger without specificity disperses. Specificity without anger is what Patricia Archer brought to a bar journal and a legislative hearing and 12 minutes at a podium, and it changed a law. Subscribe if you haven't. This channel is built on the belief that the most important stories are the ones in which ordinary people in ordinary driveways holding ordinary groceries are revealed to be exactly what they always were, which is people who deserve to stand where they are standing. Next time, we follow a black school principal in rural Tennessee who was told by his school board in writing that he lacked the leadership qualities to run his own building. And what happened 18 months later, when the same board invited a distinguished educator from across the state to come and train their principals. And the man who walked through the door of the conference room was him. The letter he carried in his jacket pocket that morning is something we will not forget. True wealth is what you give back when nobody's watching. I'll see you then.